What's up, folks? Clint Powell here with my buddy Eric Buchanan of Buchanan and Associates, and I have a question for him. I'm gonna bring him up here. Let me take that off the screen and bring him up in three, two, one. Eric, you ready for my question?
How are you?
I'm good. You ready for the question, sir?
Yes, sir.
Here we go. How does a great idea for employees go bad? So this is in your world, man.
Yeah, that's a great question. So a lot of the clients that we help have a claim that falls under a federal law called Erisa, the Employee Retirement Income Security Act of 1974. And Erisa, the original idea behind the law was to protect employees and their access to their pension benefits and their other employee benefits. And basically it had a lot of good ideas early on, and it's just gone downhill. It's almost 50 years old. It'll turn 50 and it was passed in 1974. So in 2024, it'll be 50 years old. And it was supposed to be a law to protect you and me and all of our friends that work for companies, work for employers. If you have a pension plan, if you have other employee benefits, it was supposed to make it easier to protect those rights. And it's, in a lot of ways, it's gotten harder. It has not done a good job for protecting employees.
Well, I will speak on behalf of all things over 50. It does need to be reevaluated from time to time, and maybe we need to tweak some things, right?
Yeah, when something gets 50 years old, maybe we do need to talk about it. So, but
how did it go bad? Tell me. Well, let's start with this question, if you're okay. What was its intent?
What the original idea was. What was it supposed to do? So, can we get in our time machine?
Absolutely.
And let's hop back to the early 70s. Get your platform shoes, your bell bottoms, and also get ready for inflation. Well, that's today too, but get ready for inflation in the 1970s. And in the late 1960s, early 1970s, one of the things that had become pretty commonly known was that the mob had gotten involved in union pension plans. It wasn't unusual for there to be money stolen from union pension plans. There's a great story about Jimmy Hoffa, for those who know who he is. There was a movie on Netflix called The Irishman about him. The important thing for Erisa was that Jimmy Hoffa was the head for a while of the Teamsters Union. And what the Teamsters Union was the union for all the truck drivers. And this is a great example of what was going on. That Jimmy Hoffa was supposed to be in charge of the group of people, the union leadership that was protecting all this money for these truck drivers' pensions. But instead of putting it in good investments, they would do things like loan it to himself with an interest-free loan so he could go buy a house. And then the interest-free loan might not even have a repayment schedule. So what does that mean? He basically could take the money out and never have to pay it back. So he was basically borrowing the pension money from the Teamsters, from the truck drivers. So what would end up happening if let's say your uncle was a truck driver in 1971 and he retired and he went to go get his pension, and they basically said there's not enough money to pay out all the pension benefits that we promised because the leadership made bad decisions, or in some cases even stole the money. Well, here's where we get complicated. Prior to Erisa, if your uncle lived in Tennessee, but let's say he worked for a trucking company that was headquartered in Pennsylvania, and the Teamsters Union had their headquarters in New Jersey, which state would you sue in? Which state's laws would apply?
Yeah.
Those are the kind of questions that nobody really knew the answer to, or you'd end up in a big fight.
I just real quick like the fact that you tied a Hoffa to Erisa, what you do every day. You just made it something that I can relate to. Netflix and what you do as an attorney. I appreciate you talking a little bit, bringing it down to my level, man.
It is an important part of history. So what ended up happening was it was just very difficult. What would you do to get the right person subpoenaed so that you could end up suing them in a lawsuit? Well, where did you file the lawsuit? If your uncle lived in Tennessee, let's say he worked for a trucking company in Pennsylvania, lived in Tennessee, well, was it Tennessee law that applied to how his pension would be calculated? But then did you file in Pennsylvania or Tennessee? How do you get the New Jersey money into the court? And what if the mobster who's running the thing actually lives in New York City? It turned into a total mess. So the original idea behind Erisa was to have one federal law that would protect everybody's pension rights. It would provide a system of the same rules applying all over the United States, and that employees would have the right to file in federal court. And it even had pretty loose rules about which federal court you could file in. You could file where the plan was administered. You could file where the plan was located. You could file where the breach took place, or the non-payment took place, or where the plan was administered, those kind of things. So it was all designed to make it easier.
Mm-hmm.
Before we talk about how bad it was, let me talk about a little. Let's go back. We're still back in the early 1970s in our time machine. It's Labor Day, 1974. And on Labor Day, what do we celebrate Labor Day? That's for the working people. It's
Right.
to celebrate the working people. President Gerald Ford was the president, and he was so proud of this ERISA legislation that just passed that he decided to sign it on Labor Day. And let me read to you what he said the day that he signed it. He said, "I think this is really an historic Labor Day. Historic in the sense that this legislation," talking about ERISA, "will probably give more benefits and rights and success in the area of labor management than almost anything in the history of our country." That's how excited they were about ERISA early on. It was bipartisan. It was Republicans and Democrats. And back then, the Democrats were, in a lot of ways, the party of the working class guy, but Republicans did that some too. So this is what one of the senators said the day it was passed, Senator Javits from New York. And actually, he was one of the main people who pushed for this ERISA pension reform. And here's what he said that day. This pension reform bill, he said on the Senate floor, is the greatest development in the life of the American worker since Social Security.
Wow.
That's how good ERISA was supposed to be. And by the way, I got those quotes. This is a book about the political history of ERISA by James Wooten, if anybody's interested in it. So that was the original promise. So it was supposed to just cover pension benefits, and it was supposed to make it so that your right to your pension benefits was more protected. Now, as it was going through, after they'd done a lot of the committee meetings and discussed the bill thoroughly, at the last minute, they decided instead of just covering pension benefits, they ought to make sure that stuff doesn't slip through the cracks. So they added other employee benefits, and they call those ERISA welfare benefits. And that's things like life insurance, long-term disability, and something that like 80 million Americans have is health insurance through work falls under ERISA. So all of this was put into ERISA at the last minute. And we ended up having everybody, except for some exceptions we'll talk about later, but the vast majority of people have their employee benefits fall under this federal ERISA law.
And most people, because in full disclosure, you've represented me in the past. That's how, one of the ways that I know you and your team. But most people have never heard of ERISA until they have to deal with ERISA, right?
Until you have something go wrong with your employee benefits. And by the way, it's okay to tell people we also met each other playing rugby. I don't
Well, we're doing this. Okay.
Podcast. It's okay to include that in here. But So talking about ERISA. What went wrong is one of the questions people ask all the time. Well, one of the things that went wrong was when they added the idea of the welfare benefits, your health insurance, your life insurance, your long-term disability, other than your pension, they added that at the last minute. So they didn't really think it through. They didn't have long discussions in the committees. They didn't bring experts to talk about what it might do and how
those unintended consequences, right?
Unintended consequences.
Yeah.
Another thing that turned out to be a mistake was that Congress put into the law the authority, and they specifically told the courts, we would like you to fill in the gaps and create new rules to apply to ERISA cases if we didn't cover it in the statute. So they kind of purposefully left open gaps so that the courts would develop essentially what we'd call a common law of ERISA. What are some of the fill-in gap rules of ERISA? And I will just say, historically, from the point of view of somebody who represents employees as opposed to insurance companies, employers, I think a lot of those rules that got filled in have been much more beneficial to the employer or to the insurance companies than they have been to the employees. And we'll get into a whole lot of that.
It sounds to me, and you correct me, this is where you get to be the expert, and I just get to be the guy on the outside banging on the glass. It sounds to me like this was a great idea that went bad almost immediately without us seeing it because of all the add-ons and those gaps that were left in the origin of this thing, right?
Yeah, I wouldn't say immediately, but I would say within about 15 years. So
But I
thanks,
mean, yeah,
thanks
the
for
foundation of it.
right. The foundation of it was a little shaky. The idea, if you're talking about protecting employees and working people, the ordinary Americans, those of us that have health insurance through work, those of us that have our pension through work, it's probably it covers a huge percentage of the American people, hundreds of millions of people.
Yeah.
So out of a lot of people end up being falling under the Erisa law. So where did some things go wrong? Well, one of the things that went wrong was Congress essentially cobbled together the rules from different areas of the law. So if you're the employer or the union and you're keeping all this money for your employees, is that a contract relationship that you have with your employees, or is it more like a trust relationship where you are the trustee and have a fiduciary duty?
Mm, yeah. Are you asking? Because am I guessing
Want to
or
take a
not?
guess? Yeah, take a guess.
I think it's more of a fiduciary duty, but I would imagine it's maybe not.
So what the courts originally said, and what the Congress originally said to some extent in the statute, is that yeah, it's supposed to be a fiduciary duty. So the good news is when an employer or the people running a union pension plan, whoever it is that's in charge of that pile of money, is supposed to be a fiduciary, and as a fiduciary, they have responsibilities beyond just ordinary. Or enter into a contract with each other and let the buyer beware. Instead, as a fiduciary, you have the obligation to, as a prudent person, would invest the money. As a prudent person, would give advice to the people who have pension money or about how to invest their money. As a prudent person, what advice would I give to my employees about their other benefits? So that's supposed to be the rule. Now, what ultimately happened though is in fiduciary law, in the law that applies to trust, where you have these fiduciaries also have some privileges. It's not unusual for fiduciaries to be granted discretion. So go back old days, traditional trust law that the court borrowed from Erisa. If you had a rich uncle and he left to all his nieces and nephews $1 million to be divided up 6 ways amongst the nieces and nephews, he would pick one of them to decide in his discretion when are the nieces and the trustee would be who he'd pick, would be one of the nieces and nephews, or maybe it would be a different family member, or maybe it would be a bank, whatever, maybe it would be a lawyer, but that person would be the trustee. And the rich uncle could say in the trustee's discretion, that trustee, he or she can decide when are the grandkids or when are the nieces and nephews old enough and mature enough that they can have their share of the money. And until they're mature enough, they don't get to have the money because they might throw it all away.
Right.
So that discretion rule, courts generally don't disturb. In other words, they don't go in there and say, trustee, you've got to give this money away right now to these kids. No, the court will say, we're only going to review that for what's called abuse of discretion, which is a very high standard to meet. It doesn't work so well when it's applied to Erisa, to insurance companies that are denying people their benefits, or to unions and employers that are denying pension benefits, but that's what ended up happening. So let's specifically talk about that story.
Okay.
Under the old labor laws that sometimes applied to pension benefits, under the old National Labor Relations Act, there was this idea that in some cases you could go to federal court if it was a union run plan. The National Labor Relations Board had some authority federally, and you could go to them and they would review what happened, and the board would make a decision, and then the court would give deference to that board. It's something called administrative law. It's called it's arbitrary and capricious standard review. It's a deferential standard of review. Well, what happens now in Erisa, when Erisa takes over and you don't have an independent board making the decision, but you actually have an insurance company, or you actually have a company making their own trust decisions, making their own pension decisions, do they still get deference? And this case goes all the way to Supreme Court, called Firestone Tire versus Brudge. And Sandra Day O'Connor, who was appointed by Ronald Reagan, ended up writing the decision. And she does a great job for the majority of the decision, talking about some of the same stuff we've been talking about already today. That ERISA was designed to help the working people, that the purposes of ERISA was to provide greater benefit for working people than had been provided before, that the purpose of ERISA is to protect pension benefits and other welfare benefits. And therefore, when a pension benefit or a welfare benefit is denied and you take it to court, the court is supposed to apply an even standard of review. They call it in the law what we lawyers call a de novo standard of review. She gives a great explanation as that's what the rule should be, that the court's going to weigh what you say versus what your employer says evenly and not give any benefit of the doubt to the employer. Sounds great, right?
So far, I'm on board, but I have a feeling there's a plot twist coming on.
In the last 3 paragraphs of the decision,
Here we go.
As a throwaway, she adds, but oh, by the way, just like in trust law, if the parties agree to a more limited standard of review, they can grant discretion to the decision maker, and the court should give deference to the decision maker's decisions if they have the discretion. If they're granted discretion, they can have the arbitrary and capricious standard of review.
Oh, I think I know how this got worked in. I think I could guess. I'm not going to do it because you're the expert.
Yeah, so go ahead. All right, let's hear your guess.
When I signed up, I work for a big corporation, XYZ. I accept the benefits. I sign the contract. I bet it's worked into that contract. Or am I wrong?
It's already in the contract. So here's the way she said it is when the parties agree to a more limited standard review. So when you go to work for a big company and you sign up for the company's health insurance and they have Blue Cross Blue Shield, who signed that contract?
Clint.
No,
you mean the business?
Yeah, the business signed it with Blue Cross, right?
Yep.
So who made the deal of what the policy was going to say?
Yeah,
it was the employer
business. Yeah,
agreeing with the insurance company.
Ah,
that's the parties that made the decision that there would be a limited standard of review. You're simply the beneficiary of that policy, that when you go to work there, you're covered under that policy. But you didn't get a chance to negotiate the terms of that policy.
Oh, I've got another question coming up, but keep going, man.
So just before we forget this, one little thing we can talk about later or in a different podcast is she also says at the very end, and oh, by the way, if there's a conflict of interest, if the insurance company is paying their own money, then the court should also take that into account, just like if a trustee has a financial interest in the money that it's acting like a trustee over. But she doesn't really explain that a whole lot. Mm-hmm. But here's the main point. Those last 3 paragraphs or so in the decision that say, well, it's de novo, and here's all the great reasons why it's de novo, and we're going to be fair, unless the parties agree on a more limited standard review. This was in 1989. So guess what's happened starting in 1989?
It's just got worked in, but like you were talking about.
Every insurance company put that language in their policies. If they sold it as a group policy through work, they made sure to say they had discretion. And so if somebody gets denied their health insurance benefits, their life insurance, their long-term disability, the de novo standard of review almost went away, and courts apply a deferential standard of review and say the insurance company gets the benefit of the doubt. Some courts have even defined it this way. The arbitrary and capricious standard of review means that the insurance company's decision will be upheld, even if it's wrong, as long as it's reasonable. And in fact, some have even said it has to be considered downright unreasonable in order to be overturned. And the problem is that's the kind of deference courts have traditionally, for hundreds of years, given to neutral trustees when they have discretion. But when you have an insurance company that's paying benefits with their own money, that the court, at least in Firestone Tire versus Brudge, basically said, well, that's something maybe the court should take into account, but didn't say how. But essentially, courts adopted that and turned around and gave tremendous deference to insurance companies, so that for a long time, most ERISA cases are decided where the court has to look at the facts that my clients have about their case that we help our clients get, that we get their medical records, we get their doctor's statements, we get them to go out to a functional capacity exam or whatever. And if we're helping somebody fight when they've been denied their long-term disability benefits, which a lot of the cases that we do, we will put all that together. We have to get so much information together that we not only prove our client's disabled, but that the insurance company can't deny it without being unreasonable. That's a big part of the battle that we fight.
Yeah, going back to what we were talking about just a few minutes ago, when you were talking about the original intent of this, how it was celebrated, and then those throwaway last minute additions, right? And I said, and it almost started going bad from the get-go, and you're like, no, it took a minute. This is the minute, right? We are now at that minute.
It took a minute, but it only took 15 years. It took back when you and I were in college.
Yeah.
Way back when, in the old days, they were still taking the gas lamps out and starting to put
when the phones were on the walls. We got you.
when the phones were, that's true. When the phones were on the walls, and only rich people didn't have to get up to go change the channels on their TV because they had remote controls. The rest of us had to still get up and change the channels.
Well, no, my dad never did. I got up and changed the channels, but me and you were the remote controls, man. Hey, exactly. And I know these are deep dives, and you're much more driving this. You're driving this much more than our regular podcast. So my question to you is am I allowed to ask a question real quick that may take us? So the question is, I know you well enough that I kind of know the answer to this. I want you to clarify it. I own a business. I want to start providing insurance for my employees. Do a lot of business owners even know once they enter into this contract what situation they're putting their employees and themselves in?
Yeah, that is a fantastic question. Let me give this short answer. Hell no.
Okay.
I have talked to insurance agents who don't understand how this works on a regular basis. When I buy insurance for my own law firm, I've had the conversation that I do not want language in my policy for my employees that grants discretion. And I get back this answer from the insurance company that is pure gobbledygook, word salad, that they can't do that because they've got it so built in now to their system that all their policies have it built in. So it is in reality, based on my experience, it's not negotiable anymore. It's just something the insurance companies do. And so almost every case has discretion in it. Now, I would like to talk for a minute when we're ready to about how we can sometimes get away from that and how that matters. And then we'll talk some more about some of the other bad stuff.
Well, this is your show. You're kind of driving. I just want to say before you go down that road is I did not know hell no was an appropriate answer. I feel like I might have missed my calling as an attorney. But
yeah, so also back to your question about employees, employers not knowing how it works. My firm almost exclusively, we've been around, our 20th anniversary is next year. And we have tried very hard to only represent individuals who have been denied mostly long-term disability, some health insurance, some life insurance, occasionally some pension cases. We only represent individuals or maybe groups of employees. We only represent the employees or their dependents. That's basically what we do. Mm-hmm. I do kind of as a side thing, kind of as a friendly thing. If I have an employer approach me and say, hey, I'd like somebody to look at this insurance policy. Am I doing a good deal? I'll tell them, look, I can't represent you in this, but I can give you some general information about how this works. And you're buying a policy that, yeah, that's a pretty good one, although here's the problems in it. Or here's some stuff you need to ask your insurance agent. And the big question I tell employers to ask, can I have a policy that doesn't grant discretion to the employer? And there's other things in there. For example, if you're buying a long-term disability policy for your company, most long-term disability policies offset for a person their income from Social Security and their dependent Social Security. But you can sometimes get the option that only offsets for their individual Social Security and not what their dependents get. Those are the kind of questions employers should be asking. There really need to be more attorneys who will help employers who want to do a good job for their employees. And there are some firms that do that. Hall and Associates in Atlanta, I'll give a shout out to them. If you're an employer, that might be a good place to go talk to. My focus, so I don't end up in a conflict of interest, is the only people I officially take on as clients are the people who have claims under these ERISA plans or other insurance claims.
Well, you help clients and people all around the country, but I will say this: it may not be that there's a whole lot. There may not be a whole lot employers can do. There may be wiggle room, the right questions, but I think one of the biggest benefits is just knowing what are the expectations, what could go wrong, and as an employer, then at least I know what to expect. I'm aware of the deadlines and what happens if this happens, what happens then. So sometimes just setting expectations is important.
Sure.
Yeah. All right.
Let's talk. Let me, if you don't mind, let me talk about a couple of the ways that ERISA went wrong. So one of the other things that happened, because courts use this model of trust law, they also went out and they borrowed some from the idea of administrative law. And administrative law is, for example, if you're suing an administrative agency like the Social Security Administration because they're not paying your benefits, or if you own a radio station and you're suing the Federal Communications FCC because they won't give you a license for a second radio station, and you disagree that you should have the right to do that, whatever it is. A lot of those type of agencies, the first level of decision is made by an administrative law judge, somebody who actually works for the agency. And then if you have to take it to court, the court not only gives deference to the decision by the administrative law judge. Sound familiar? Because that's similar to ERISA where you get deference. But on top of that, what the courts have said in administrative law cases is that whatever information the court is going to review is limited to the information that was submitted to this administrative law judge. It's a closed record. You're not allowed to have witnesses come testify in court. You're only allowed to have your witnesses and your documents originally in front of the administrative law judge. And what happens in America, there's so many different types of administrative law that people have to deal with, that some people do it, they don't know that they need to get an attorney to help them put the record together. That happens sometimes in Social Security cases, sometimes in other areas of law. Well, the court basically borrowed that concept and applied it to ERISA. So another way that ERISA has turned out to be worse for the employee and better for the employer is they've applied this concept of a closed record and said, if you get denied your health insurance, your life insurance, your long-term disability benefits, and you take your case to court, the court is only going to look at the documents that were submitted to the insurance company. That's why it's crucial to talk to an attorney and usually hire one to help you with that appeal, to build that record up and to make sure you have a good case when it goes to court. The toughest cases we have, Clint, we just lost one we have against a local insurance company for a client that I think is really disabled, but she did her appeal on her own. And so we had an uphill fight. We could only argue about the documents that were actually in that record, as opposed to helping her early on. And we help people early on. We end up winning some of those cases and never have to take it to court. We get the insurance company to change their mind. And when we do go to court, we have a much better record because we've gotten in there the stuff we know is going to make it a better case, that's going to make it so good that the insurance company can only turn it down by being unreasonable. That's our goal, and that's what we can do in a whole lot of cases. But if somebody tries to develop the record on their own, tries to submit what they want to the insurance company, doesn't know what makes it a good case, and then doesn't hire an attorney until after they've been denied, that's a real problem because the court won't let us add additional evidence. So that's another way that ERISA has turned bad.
Well, I want to add an anecdotal. This is where I can speak a little bit to this. You get the letter from the insurance company, and I've said this 1,000 times, and on the back it's written in 4 font, and it's got these legalese, and there's 12 different deadlines, or it's 30 days here, 15 days there. What people don't realize is you may be a really smart person. You may own a business. You may be graduate top of your class, but you don't understand that language on the back or the in the contract with that insurance company is setting you up to, if you don't turn that information in by deadline. To me, that's the biggest thing that you miss. It's not that I may get the documents from my doctor and my employer. I may have witnesses. I may have a folder. But if I don't notice that deadline is amongst the other 4 dates on that thing and miss it by 2 or 3 days, I'm out.
Yeah, so not only understanding what information to submit, but how to submit it on time.
Yes.
Those are mistakes that people make before they hire an attorney. That's a huge part of it. Not understanding what good arguments you're going to be able to make in court if your case goes that far, by making sure you have the right stuff in the file. Let me give another example of a way that ERISA has gone bad.
Well, can I just want to add one more anecdotal thing, and you can give another idea, but The other thing, the reason I really, and I'm glad I reached out to you and your team, is because you work with doctors. So you and the employers, you know the right questions to ask. It's not just that I might get good information, but specific information with clarity. And doctors know how to answer those specific questions. It's more than just getting a file and turning it in.
Yeah, that's a great point, because a lot of what happens in these cases is it's not just somebody's medical records that count. It's what do their doctors say about what they can do? What are the restrictions? What is our client's restrictions? What are our client's restrictions and limitations? How much can they lift? How long do they have to lie down during the day? Whatever, how bad is their concentration? Whatever the problem is that makes it so that they can't work anymore. That's the kind of stuff that's really important to get into the file. Just getting your medical records often doesn't cover that stuff. And most clients understand that. Occasionally we get somebody who calls us up and says, well, I think I'll do my appeal on my own. And okay, good luck, Charlie. That,
Yeah.
I just don't think that's ever a good idea. It just, because it takes a level of experience and expertise to put that record together and to understand what needs to go in the file.
The
And
smartest among us know we're not, when we're not smart, and we reach out to other smart people. I interrupted you about going down the path of other things
yeah, so I
that are
was going
not
to give
good.
another example of how ERISA has been under how it's supposed to help the working person, the employee, the person with a policy, with a pension. So remember that Congress told the courts that the courts could fill in the gaps of ERISA.
Mm-hmm.
Well, one of the gaps that ERISA has left wide open is just exactly what are the rules that an insurance company or a pension or a self-funded plan run by the own employer, what exactly are the rules they should follow in deciding if somebody's disabled or not? You have a policy that defines disability as being unable to work in your own occupation or something like that, or being unable to work in any occupation. Uh, and so there's different definitions of that, but it doesn't go into a whole lot of detail. So one example would be, here's a classic question. If the insurance company's doctor says you can work and your doctor says you can't work, should the insurance company go with their own doctor or go with your doctor? So in historically in disability law, that's called a treating physician rule, that the treating physician's opinion should be given controlling weight if it's consistent with the rest of the record and not contradicted by any significant evidence. So that rule used to apply in Social Security cases. Interestingly, over the years, the regulations have changed there, and they've taken it away in Social Security cases. They have something different now. So back in the 1990s, there was a series of cases in a bunch of different circuits. So below the Supreme Court in the United States, there are 11 numbered circuits, 1 through 11, and then there's a couple other circuits, the DC circuit, and stuff like that. Those circuits started to develop a common law of ERISA, just like Congress told them they could do. And one of the rules that they said was, well, if your treating doctor who's treated you for any length of time says that you're disabled or says you have these restrictions, limitations, that should generally be given more weight than an insurance company's doctor. That was exactly what Congress told them to do, and to create that rule. What happened?
I don't know, but I feel like there's another plot twist coming on. There's another butt coming in, isn't there?
The big butt was a case called Black and Decker versus Nord. And a friend of mine, Larry Rolfe, and I hate to name him that way because he's a great guy, but he was the attorney that took that case to the Supreme Court. He fought hard. I swear, Larry's a great guy, and he fought hard. He lost that case in the Supreme Court. And the Supreme Court said, no, there's nothing in the ERISA regulations that says you have to give more weight to the treating doctor. Therefore, we're not going to let judges just make up this rule. But the problem was the Congress had already said the judges could make up a common law of ERISA. And the Supreme Court said, yeah, but that, they didn't say it out loud, but effectively what it sounds like is, yeah, but that one helps the employees. And so you can't make up that rule.
Right.
Now, one of the interesting parts about it, I think this is just kind of fun to talk about, fun and interesting, not good for our clients. I hate it for them, but just how the background of this is. So if you look at the Social Security regulations, the book that has all those different rules of how you determine if somebody's disabled is about that thick of different rules, right?
Like 4 inches, 3 to 4 inches. Yeah.
Right. The similar book for Erisa looks like this.
Oh my!
And by the
Hey,
way, this is volume 2. There's actually 2 books this size.
well, wait a minute, because people may listen to this on audio podcast down the road. He's holding up what looks to be like a 1975 phone book
Yeah,
that is
I think that's a good
huge.
solid 4 inches,
Oh yeah,
three
yeah,
and a half
that's
to
a
4 inches thick.
yeah.
So the whole regulations are about 7 pages thick. However, the vast majority, almost all of these pages in here are ERISA pension regulations and tax regulations. There are less than 20 pages in here that have to do with disability. Only about 20 pages out of all of this. So
Wow.
where Social Security has a book that's about 2.5 inches thick, ERISA only has about 20 pages at most that cover disability. And in fact, I would say really only 12 of those pages really get into the rules. And most of those rules are procedural. You have to make it, the insurance company has to make a decision with a certain amount of time. There is a little bit that they have to at least state the reasons they're denying the claim, and then they have to give they have to explain what you need to perfect your claim. There's been a recent change starting for claims filed since 2018 that the Trump administration, their Department of Labor actually issued some new regulations that said you have to at least address what the treating doctor said. And that's a new rule, but it only applies to people that filed a claim since April 1st of 2018. But it doesn't say that that necessarily gives controlling weight, which judges had said for several years. And then the Supreme Court took it all away in this case called Black and Decker versus Nord.
But isn't that a small step? I mean, sometimes we look at this as incremental, but is bringing that back to at least having to be addressed? Isn't that a incremental small step back in the right direction?
Yeah, and people who, I'm not going to get into politics,
No.
but you might be surprised to know that the biggest change in the ERISA regulations in those 10 or so pages that really matter, the best thing for claimants that has happened in a long time was put out by President Trump's Department of Labor. It was issued, I think, in 2016. It's supposed to go into effect well, let me say it this way. It was actually originally written by the Obama administration.
Okay.
When the Trump administration came in, they put it on hold for a little while, but they didn't change it, and they adopted it. And so they allowed it to go forward. And so originally the effective date was January 1st, 2018. They moved it to April 1st of 2018, and that's all they did. So if you have a claim where you originally filed your claim after April 1st of 2018, you get the protection of these newest regulations.
Good.
For example, you get the little bit, they have to address your treating doctor. Don't have to give it more weight, but they have to at least address your treating doctor. Another change that they made was that if the insurance company violates the rules by not making a decision on time, or violates one of the other rules in those 10 pages by not giving the right information in their letter, a few other technical rules like that, then they can lose their discretion, and that goes back to de novo. So that's a
Oh.
big advance that happened. And no matter where you are politically on this, 2 administrations in a row basically worked on those changes, and that's what the Department of Labor came out with, was regulations that actually help make up some ground that the courts had taken away all the benefits of what ERISA was originally supposed to do, to be one of the greatest benefits for the working man since Social Security, like that one New York senator said back in 1974.
Well, and I'll say this, and then I'll let you take it down whatever path you need to. As far as anything else that's kind of gone in awry since this was enacted, but a lot of people won't even, if you don't have an attorney, or you don't even know when the insurance company may have made the mistake. They may have missed the deadline, the procedural stuff, and you may just throw your hands up and go, hey, it is what it is. I got denied and I'm just going to complain about it, or I might get. There's so much that happens. You may not even be aware that they have put themselves in a vulnerable spot.
There's not only that. Here, let me be more let's make an important point.
Yeah.
If the insurance company misses a deadline, they might lose discretion. If my client, before they hire us, misses a deadline, they've lost their case. It's over.
Man, well
if you miss the
put.
deadline, you're done.
You should be an attorney, dude. That's it.
You're right. That's another reason we have to get involved. So
Yeah.
the more that we can help early on, the more we can make sure that we will make sure our clients' deadlines are met. Obviously, that's what we do as attorneys, is follow those rules. But we will also hold the insurance company's feet to the fire when they don't follow the rules. Unfortunately, another example of how ERISA is unfair, though, if our client doesn't follow the rules, their case is done. They can't
Yeah.
appeal again. They've missed the deadline. If the insurance company misses the deadline, they have a chance to win. They just might lose their discretion.
Yeah.
Super
I'm
fair,
glad you
huh?
made that kind of sorted it out. What else do we got to talk about as far as how this went from a great idea to maybe in practicality not the best thing for employees?
So let's cover one last important point, and then we can save some more for some future podcasts and videos on this, Clint. And the other one is, what's the incentive for the insurance company to pay these cases under ERISA? And by that, um, if the insurance company loses the case, what do they have to pay?
The settlement. They have to whatever was in the contract, right? The insurance agreement.
Right, they have to pay the benefits they were going to pay in the first place.
Right. That's it.
Right. The Supreme Court has said in a couple cases that basically you cannot sue, that I can't sue on behalf of my client for bad faith or punitive damages or what's called extra contractual damages, to try to get more for our clients than what was promised as punishment for the insurance company making them go through this. Now, good news, we'll set this aside for a second. ERISA does allow for me to sue for my clients to get attorney's fees paid, but it's not based on a percentage that attorneys usually charge in these cases. It's based on the number of hours and the hourly rate the attorney can be awarded by a court. It makes up for a little bit of the attorney's fees. It helps some.
Mm-hmm.
It's a Band-Aid on a big cut. It's not going to completely heal the wound. What really, though, is I think another horrible part of ERISA is that our clients can't sue for the financial harm, for the emotional harm, or more importantly, to punish the insurance companies to get them to not do it again. So let's look at it from the point of view of the insurance company. If they can deny thousands of cases a year, and some of those people don't know how to hire an attorney, what happens to the money that the insurance company would have paid on those
Keep
claims?
it. Keep it.
And then some people mess up their appeal. What happens then?
They keep it.
So some people actually hire an attorney and do a good job, but still lose. What happens there?
Keep it.
Now, some people hire an attorney, do a good job, and actually get their benefits paid. The insurance company has to pay what?
Only what they agreed to. That's it.
Right. So if their original obligation for 1,000 policies was $100 million, and 20% of the people don't appeal, that saves them $20 million. 20% of the people do a good job appealing, they go away. That saves them another $20 million. So they've just made $40 million off of that bucket of cases.
That's right.
And of the other 60 million, they might win some, they might lose some, but they're never going to have to pay a big penalty for having cheated or lied or made an unfair decision or have any kind of goals to deny claims or any kind of targets or financial incentives or any of those things that insurance companies are accused of doing. There's no punishment for any of that.
No, they got to keep 70 million maybe of that 100 million, and they profited off of the denials.
Bingo.
Yeah.
And there's no punishment. Now, the good news is if you have a case that's not ERISA, some states have good law that you can sue for punitive damages or bad faith. But that's another future issue. We will talk about this in an upcoming podcast. Why does ERISA apply sometimes and why does it not? And how do you wade through that mess? That's worth another deep dive, and we'll talk about that.
Yeah.
But for today, I kind of want to wrap it up with ERISA cases are not impossible. There are some tools that we have that we can use to win some cases. We've been doing it for a long time. And yes, we do win cases. And yes, we help people get the insurance company to change their mind. Yes, we win in court sometimes. And yes, we can get decent settlements. But these cases are very different than what you see on TV, where you have a right to a jury trial and you have a right to sue for the millions of dollars you might get to punish an insurance company. And these are very technical rules. And ERISA, that was promised to be a great step forward for working people and people who are employees, has turned into, in many ways, an advantage for the insurance companies and the employers.
And just to tease it a little bit, one of the topics we will be talking about over the next few releases is why we don't get a jury trial That and along with several other topics, but we're going to do a series of these, and I'm looking forward to it. Eric, make sure everybody knows how to get a hold of you and your team because you do work all around the country.
Yep. So we have 6 attorneys, including me, but we work with other local attorneys around the country in those places where we're not admitted. We work with them as local attorneys. So we handle cases basically anywhere in the United States. We've had clients in Alaska and Hawaii. We've got cases right now in New York and Pennsylvania and other places around the country. California, I think we still have one right now. We do help people all over. And if you have been denied long-term disability, disability insurance, health insurance at work, or health insurance in a private contract, life insurance. Those are all the types of cases we have helped people with. If you have a pension that provides disability benefits, that counts. That's something we've helped people with before. Whether or not it's ERISA, we can handle it either way. And one of the things that we bring to the table at our firm is we've done a lot of fighting over whether ERISA applies. And we've successfully gotten some cases out from under ERISA, for example, when the other side said it was. It's part of our that's what we have to do to help our clients. Is what we do for a living. We've been doing this for a long time, almost 20 years, coming up on that anniversary, but I was doing it before I even started this firm, and we help people with these problems with ERISA, non-ERISA. If you have an insurance problem, call us.
BuchananDisability.com. Is that a good place?
That's a great place to go. Maybe you found this video there, so if you did, that's great. We're in Chattanooga, Tennessee, but again, we work all over the United States. Check us out at BuchananDisability.com. Check out our other videos and papers. Play around on our website. There's a lot of information there for curious people that want to know more.
Thank you, Eric Buchanan. I appreciate it, buddy.
Great job, Clint.
Bye, everybody.
See ya.